September 17th, 2025, Florida, 6 o'clock in the evening. Somewhere inside a prison surrounded by tall fences and concrete walls, a 63-year-old man is lying on a table. His arms are stretched out, his eyes are open, and in just a few minutes the state of Florida is going to put him to death. His name is David Joseph Pittman, and with his very last breath, in front of witnesses, in front of prison officials, in front of the whole world, he said something that stopped people in their tracks. He said, "I know you all came to watch an innocent man be murdered by the state of Florida. I am innocent. I didn't kill anybody. That's it. Now, people say a lot of things before they die. But here's what makes this story so strange, so unsettling, so hard to just forget about. There are people, real lawyers, real judges, real human beings, who are not sure he was lying. So today, we are going to go back to a small Florida town, back to a family that nobody outside of Polk County had ever heard of, back to a marriage falling apart at the seams, and back to a night that changed everything. Because the story of David Pittman is not just about one man. It is about what happens when a community is shaken to its core. It is about justice and the long, painful road it sometimes takes to arrive. It is about a family that waited 35 years for peace, and it is about a question that no court was ever fully able to silence. What if the wrong man died on that table? Before we go anywhere, we need to stop right here. If you are watching this and you want to understand what really happened, not just the headlines, not just the verdict, but the full picture, then stay with us. And if you haven't already, hit that subscribe button right now and turn on your notifications, because this story is just beginning. And trust me, you do not want to miss what comes next. Now, let's go back to the beginning. Let's go to a place called Mulberry, Florida. Mulberry is a small town in Polk County, Florida. It sits east of a city called Plant City, surrounded by phosphate mines and orange groves. In 1990, it had just over 3,000 people. Everybody knew everybody. Neighbors waved at each other from their porches. Children played in the street until dark. It was that kind of place, the kind of place where something terrible was the very last thing anyone expected. Now, if you were living in Mulberry in May of 1990, you probably knew the Knowles family, or at least knew of them. Clarence Knowles was 60 years old. His wife, Barbara, was 50. They had daughters. They had a home. They were, by all accounts, a regular family, the kind of family that you find in every small American town. Good people, quiet people, people who did not bother anyone. Their daughter Bonnie was 21 years old. She was young. Her whole life was in front of her. Nobody could have guessed what was coming for them. Now, into this picture, enter a man named David Joseph Pittman. David had married into this family. His wife, a woman named Marie, was connected to the Knowles. And for a time, David Pittman was just another face in the community, a husband, a man trying to make his way in the world. But by the spring of 1990, things between David and Marie had fallen apart, completely fallen apart. Marie had filed for divorce. And when she did, something inside David Pittman, according to prosecutors, began to burn. Now, divorce is painful. Most people know that. When a marriage ends, it can feel like your whole world is crumbling. People get angry. People say things they don't mean. People sometimes lose control of their emotions. But what investigators would later claim happened next, that was not just anger. That was something far more dangerous. According to those who knew what was going on at the time, David Pittman did not quietly accept the end of his marriage. He made threats, not once, not twice. Multiple times, investigators say David Pittman threatened to harm Marie's family, the Knowles family. Think about that for a moment. He did not threaten just one person. He apparently threatened the entire family. And those threats, people would later say, were not empty words. May 15th, 1990. That date is important. Write it down if you have to, because we are going to come back to it again and again. May 15th, 1990 was a Wednesday. A regular day in Mulberry, Florida. The sun came up. People went to work. Kids maybe came home from school. Nothing on the surface looked unusual. But at some point that day, someone went to the home of Clarence and Barbara Knowles, and they did not come to talk. Now, before I tell you what investigators found, and this is important, understand that what we know about that night came mostly from evidence gathered after the fact. Investigators pieced it together like a puzzle. They worked backwards from what they found to try and figure out what happened and who was responsible. Here's what they found. The phone line to the Knowles home had been cut, not broken by accident, not snapped by a storm, deliberately cut. Someone had made sure that the people inside that house could not call for help. Think about what that means. That takes planning. That takes someone who thought ahead. Someone who knew what they were about to do and made sure there was no way out. Inside the home, they found Clarence Knowles in the living room. Barbara Knowles was found in a hallway, and Bonnie Knowles, just 21 years old, was found in her bedroom. All three of them were dead. And then, to make matters even more terrible, the house had been set on fire. The person who did this had not only taken 3 lives, they had tried to burn the evidence along with them. The news of what happened to the Knowles family spread through Mulberry like wildfire. People were horrified. People were frightened. A whole family, had been wiped out in one night, in their own home, behind their own walls, in the town where everyone was supposed to know everyone. And the question on every single person's lips was the same. Who did this? The answer, according to investigators, came fairly quickly. And when the names surfaced, when detectives started piecing together the threats, the motive, the timing, the focus landed on one man, David Joseph Pittman, the estranged husband. The man going through a bitter divorce. The man who, investigators said, had threatened this very family. He was arrested shortly after the murders. And almost immediately, David Pittman said that he did not do it. Now here is where the story starts to get complicated, because in any criminal case there are 2 sides. There's the story the prosecution tells, and there's the story the defense tells. And sometimes, not always, but sometimes those 2 stories are so different from each other that it is hard to believe both sides are talking about the same case. The prosecution in David Pittman's case had a narrative, a clear, simple, powerful narrative. David was angry. His wife was leaving him. He had threatened her family. He had motive. He had opportunity. He had made his intentions known, and then he carried them out. And they had evidence to back it up. A witness who saw someone running away from Bonnie's burning car. A person in jail with Pittman who claimed David had confessed to the killings. That is not nothing. That is 2 witnesses pointing the finger directly at David Pittman. But here is what David Pittman and his lawyers said. They said the case against him was built almost entirely on people's words, not on hard physical evidence. No fingerprints, no DNA, no weapon with his name on it. Just two witnesses, a witness at a burning car and a jailhouse informant. And here's a fact worth knowing. Jailhouse informants, people who claimed someone confessed to them while behind bars, are one of the most questioned sources in the entire criminal justice system. Not because they are always lying, but because they sometimes have very good reasons to lie. Reduced sentences, better conditions, deals made with prosecutors. That does not mean this particular informant was lying, but it means you have to ask the question. The defense asked it. The jury, it seems, did not find it convincing enough to change their decision. In April of 1991, less than a year after the Knowles family was killed, a jury found David Joseph Pittman guilty. Guilty on 3 counts of first-degree murder. Guilty of arson. Guilty of grand theft for stealing Bonnie's car. And on April 25, 1991, the judge handed down the sentence. Death. David Pittman was going to die for what he had done. But here is the thing that nobody standing in that courtroom could have fully understood in that moment. David Pittman was not going to die any time soon. He was going to wait for 34 years. 34 years inside Florida State Prison. 34 years in a small cell. 34 years of appeals and legal filings and arguments and denied petitions. 34 years of a family waiting for justice. 34 years of a man insisting he was innocent. There is something deeply strange about the death penalty that most people don't fully think about. The sentence is the most final thing a court can do. There is no coming back from it. And yet, the system that delivers it is one of the slowest systems in the world. Death row inmates in the United States often wait decades. Decades in which the world moves on, children grow up, technology changes, people forget, and the person sitting in that cell just waits. What does that do to a person? We do not know exactly what David Pittman felt during those 34 years. We don't have a diary. We don't have every letter he wrote or every thought he had. But we know this. He never stopped saying he was innocent. Not once. Through every appeal. Through every court filing. Through every hearing. Through every year that passed. David Pittman said the same thing he would say at the very end. I didn't do it. Now there is one more piece of this story that we need to introduce before we go deeper. And it is a piece that adds an entirely different layer of complexity to everything. Late in his time on death row, David Pittman's lawyers raised something new. They argued that David Pittman was intellectually disabled. Not his fault, not something he chose, something he was born into, shaped by, trapped inside of. They pointed to his IQ scores in the low 70s, which placed him at the edge of what the medical community considers intellectual disability. They said he had trouble reading basic words, that explanations had to be repeated to him multiple times for him to understand, that his mind simply did not work the same way most people's did. And here's why that matters. In 2002, the United States Supreme Court ruled in a case called Atkins v. Virginia that it is unconstitutional to execute a person who is intellectually disabled. The Eighth Amendment, which bans cruel and unusual punishment, protects them. In other words, if David Pittman was truly intellectually disabled, the law said he should not die. His lawyers fought hard on this point. A judge, a real judge, sitting in a real courtroom, looked at the evidence and said openly that there was a real risk Florida was killing a man tonight who was lawfully ineligible for execution. Think about that sentence. A real risk. A judge said those words out loud, and the execution still moved forward. The Florida Supreme Court denied his claims. The United States Supreme Court, on September 16, 2025, just one day before the execution, denied his final appeal. The clock kept ticking. And so we arrive back where we started. September 17, 2025, Florida State Prison, near the city of Stark. Outside the prison gates, people have gathered. On one side, a church group that travels 2 hours from Daytona Beach to attend every single execution. They bring chairs and tents and speakers. They pray. They sing. They believe that no matter what a person has done, something sacred is present in their final moments. On the other side of a small grassy area, a group of death penalty opponents hold signs, some with Bible verses, some with simple phrases, "Not in my name." They ring a bell as the hour approaches. Inside, the family of the Knowles, the people who survived, who grew up without their mother, their father, their sister, are seated as witnesses, waiting for something they have been waiting for since 1991. And inside a small room in that prison, David Pittman is prepared. A 3-drug injection, a sedative, a paralytic, a drug that stops the heart. At 6 p.m. the process begins. David Pittman speaks his last words, and then he takes a few deep breaths, and then he is still. At 6:12 p.m., David Joseph Pittman is pronounced dead. Outside the prison, just after 6:15, something strange happens. A ray of sunshine breaks through the clouds above the prison, and it scatters into a myriad of colors, like a rainbow right there above those walls. The church members say it is a sign that God was present. Make of that what you will. But what we can say with certainty is this: 2 groups of people left that prison that evening with completely different feelings in their hearts. The family of the Knowles, who had waited 35 years, felt something they called closure. Nephew James Geddes spoke afterward. He said the execution brought a measure of closure to this tragic event 35 years ago. He said, "Justice has been served," and on the other side, David Pittman's own family, who had visited him in his final hours, walked away in grief. 2 families, 2 sets of broken hearts, both of them real. So now you know how this story ends, but here's what you don't know yet. You don't know who David Pittman really was, where he came from, what shaped him, what his life looked like before all of this. You don't know the full picture of what happened on May 15th, 1990. Not really. You don't know what went on in that courtroom in 1991, what the jury heard, what they didn't hear. And you don't know what happened during those 34 years on death row, the appeals, the decisions, the moments where the system came close to changing course. There is so much more to this story, and that is exactly why we are going to keep going. Before we do, drop a comment right now. Tell us, based on everything you've heard so far, what do you think? Do you think justice was truly served? Or do you think there are still questions that were never properly answered? We want to hear from you, and your comment might just shape the conversation in the next part of this documentary. Stay with us, because the deeper we go into this story, the more you're going to realize. Nothing about David Pittman's case is as simple as it looks. There is something about the dark that people forget. In the dark, you can do things that the daylight would never allow. A person can move through a neighborhood without being noticed. A plan that seemed impossible in the sunshine suddenly starts to look like it might actually work. And in the early hours of May 15th, 1990, somewhere between midnight and 3 in the morning, something moved through the darkness of Mulberry, Florida. Something that knew exactly where it was going. We are going to go deep into that night today. Every piece of evidence, every witness, every detail. And by the time we are done, you are going to understand, really understand, why this case troubled so many people for so long. But we have to start with a question that nobody fully answered. What happened in the hours before the Knowles family was found dead? To understand that, you first have to understand the weeks and months leading up to it, because nothing about that night came out of nowhere. David Pittman and Marie were not just going through a divorce. By the spring of 1990, their separation had turned into something far darker. David had become, according to investigators, a man consumed by anger. Anger at his wife. Anger at the divorce, and most of all, anger at the Knowles family. In his mind, they had become the people responsible for taking Marie away from him, the people standing between him and what he felt he deserved. Investigators say he made threats, not quiet, private ones, loud ones, repeated ones, the kind of threats that stick in people's memories. The kind that, when something terrible happens shortly after, come rushing back with a cold and terrible clarity. But here is where the story gets even more complicated. Because underneath all of this, underneath the divorce, the anger, the threats, there was another layer, a darker one that had been quietly building for years before any of this ever came to the surface. Before the murders, before the divorce. Around 1985, Bonnie Knowles had told people that David Pittman had raped her. She was young. She went to the authorities. She tried to press charges, but the case was dropped, not because nobody believed her. The statute of limitations, the legal time limit on when a charge can be filed, had already closed the window. Bonnie never got her day in court. But here is the part that matters most for this story. Just before the murders, Bonnie had apparently tried again. She had made another attempt to revive those allegations against David Pittman. The case was dropped once more. The law still stood in the way, but David found out she had tried. And according to people who would later sit inside that courtroom and testify, that is when the temperature of everything around David Pittman went from hot to something far more dangerous. There was one more piece of context that investigators found deeply significant. David Pittman was not even a free man when all of this was unfolding. He had been serving time in state prison on an unrelated charge. And it was while he was still behind those bars that Marie had served him with divorce papers. Think about what that moment must have felt like. You are already in prison. You receive papers telling you your marriage is over. And then you find out that your wife's younger sister, the one who had once accused you of something terrible, is trying to press those charges again. Every wall closing in at once. Most people, faced with all of that, would fall apart, would grieve, would eventually accept what they could not change. But according to prosecutors, David Pittman did not look for a way to accept it. He looked for a way to make it stop. And what he did next, investigators say, was not the act of a man overwhelmed by emotion. It was something deliberate. Step by step, thought out in advance, it was a plan. At approximately 3:10 in the morning on May 15, 1990, A newspaper delivery driver was making his usual rounds through the quiet streets of Mulberry. A routine shift, half-dark roads, the kind of early morning work that feels like the whole world is still asleep. And then he saw it, a burst of orange flame on the horizon. Not a small flicker, a violent, sudden eruption of light in the Florida darkness. He called the police immediately. When emergency responders arrived at the Knowles home, they found it completely engulfed, flames pouring from every window, heat radiating out onto the street. Firefighters worked to bring the blaze under control while investigators waited. When they finally got inside, when the smoke thinned enough to enter, what they found confirmed that this was no accident. 3 people were dead. Clarence Knowles, 60 years old, found in the living room. Barbara Knowles, 50 years old, found in the hallway. Bonnie Knowles, just 20 years old, found in her bedroom. A medical examiner would later confirm what the state of the scene already suggested. The fire had not killed them. The cause of death in every single case was the same: multiple stab wounds and severe blood loss. These 3 people had been gone before the first flame was lit. The fire had been set deliberately, after the fact, to burn the evidence along with the house. Now investigators had a crime scene, and they began picking it apart piece by piece. The first thing they noticed was the telephone line. It had been cut from outside the house. Not damaged by the fire, not broken by accident. Someone had approached the home before entering, found the telephone line on the exterior wall, and deliberately severed it. In 1990, that landline was the only way to call for help. Whoever cut it knew that perfectly well. They had removed the family's last lifeline before going in. That single detail changed everything about how investigators understood this crime. This was not a moment of rage. This was not someone who snapped. This was premeditation. Cold, deliberate planning. Someone had stood outside that house, in the dark and the early hours of the morning, and calmly prepared for what they were about to do. And then they went in. The second piece of evidence was Bonnie's car, a brown Toyota, missing from the scene entirely. It turned up about half a mile away, abandoned in a ditch near a local construction site. Later that same morning, a construction worker arrived at his job site and noticed the Toyota just sitting there in that ditch. Something about it felt wrong. And then, while he stood looking at it, a homemade record truck pulled up near the car. He watched it, and he would later be able to describe it. Police showed him photographs, and he identified that truck as belonging to David Joseph Pittman. Shortly after the wrecker appeared, a cloud of black smoke began rising from the direction of the Toyota. Someone was burning it. A woman living nearby also saw the smoke. She looked out in time to see a man running away from the burning car. When police showed her a photo lineup, a collection of photographs of different people, she pointed without hesitation to one face. David Pittman's. 2 witnesses. One who placed David's truck at the scene of the burning car. One who placed David himself, running, fleeing, leaving behind more fire and more destruction. That was the physical thread connecting him to the crime, but the most powerful piece of evidence in the entire case did not come from the street or the construction site. It did not come from any physical location at all. It came from inside a jail cell. After the murders, David Pittman turned himself into police. At the encouragement of his own mother, he walked into the police station the very next day. He was arrested and placed in custody, and while he was there, he ended up sharing space with another man, a man named Carl Hughes. Carl Hughes would become the most important witness the prosecution had. Hughes testified in open court that David Pittman had told him everything, confessed to him in full detail. According to Hughes, David said he went to the Knowles home that night, intending to speak with Bonnie. She let him in. And when things did not go the way he wanted, he killed her. Then he moved into the hallway where Barbara was, then to the living room where Clarence was trying to reach the phone whose line had already been cut from outside before any of it started. The jury heard every single word of that testimony, and this is the moment where we have to stop and think carefully, because this is one of the most important and most debated parts of the entire case. A jailhouse informant. Those two words carry enormous weight inside the American criminal justice system. For decades, jailhouse informants have been one of the most questioned and controversial sources of testimony in American courts. The reason is not complicated. These informants very often have something to gain from their testimony. A reduced sentence, better prison conditions, charges dropped entirely, deals made quietly with prosecutors in exchange for standing up in court and pointing the finger. That creates a powerful, obvious incentive to say whatever the prosecution needs to hear, whether or not every detail of that story is the truth. Now, this does not mean Carl Hughes was lying. Nobody can say with certainty what was or was not said in that jail cell. It is entirely possible that Hughes heard exactly what he claimed to have heard. Guilty people do sometimes unburden themselves to the person sleeping closest to them. But the defense made a clear argument. There was no recording, no written note, no physical evidence that any confession ever happened. Just one man's word against another. And the defense asked the jury a simple question. If David Pittman was planning to stand in court and deny everything, why would he turn around and confess every detail to his cellmate? It is a fair question. It has a fair counter-argument, too. And 12 people sat in that jury box weighing both sides. The jury believed Carl Hughes. In April 1991, less than a year after 3 members of the Knowles family were killed, David Joseph Pittman was found guilty on all counts. 3 counts of first-degree murder, arson, grand theft for taking Bonnie's car. Then came the penalty phase, the part of the trial where the jury decides between life and death. They voted 9-3. 9 members of that jury said death. 3 said something else. 3 people sat in that room, heard the same evidence, and were not ready to send this man to his death. We will never know exactly what those 3 were thinking, but that number 3 is worth keeping in your mind as this story continues. On April 25, 1991, the judge made the sentence official. Death 3 times over. David Pittman was removed from that courtroom and transferred into the system that would hold him for the next 34 years. Florida State Prison near the city of Stark, a maximum security facility where the days blur together and the outside world feels like something from another life. And there, in that prison, David Pittman did something. He fought through every appeal, every legal filing, every denied petition, every court that said no. He kept fighting, and he kept saying the same thing every single time, without variation, without compromise. I didn't do it. While David sat in that cell, something important was happening in the outside world. In 2002, the United States Supreme Court handed down a ruling that would become one of the most significant decisions in death penalty law. In a case called Atkins versus Virginia, the court ruled that executing a person with an intellectual disability violated the Eighth Amendment, the part of the Constitution that prohibits cruel and unusual punishment. David Pittman's lawyers looked at that ruling and saw a crack in the wall. They argued that David had an IQ in the low 70s, right at the boundary of what the medical and legal communities recognize as intellectual disability. They said he had been placed in special education classes as a child, that he had suffered brain damage, that basic reading was nearly impossible for him, that instructions had to be given to him multiple times before he could fully process them. And then they told the court something about David's childhood that added a different dimension to everything. His mother had beaten him regularly. She had told her children plainly that if they ever reported her to Child Protective Services, she might spend a day or two in jail, but when she got out, they would end up in the hospital. Those were her exact words to her own children. An advocacy group that later spoke publicly about the case said it simply: violence, neglect, and hardship shaped David Pittman's life long before the state ever called him a defendant. None of that excuses what happened to the Knowles family. 3 people, Clarence, Barbara, and Bonnie, lost their lives in their own home, in the dark with no way to reach out for help. Nothing changes that. But there is a difference between excusing something and understanding the full picture. And there is a separate legal and constitutional question, entirely apart from guilt, about whether a man who may have been intellectually disabled from childhood can lawfully be put to death under the Constitution of the United States. In 2020, the Florida Supreme Court effectively closed that door. They ruled that certain disability protections could not be applied to cases already decided before the law changed. The protection existed, but because of the timing of events, it was ruled too late to help David Pittman. His attorneys took the fight all the way to the United States Supreme Court. They asked for a stay of execution, just a pause, time enough to hold a real, proper hearing on the disability claim. A sitting Florida judge had already said publicly that there was a real risk the state was about to execute someone who was legally ineligible for that punishment. On September 16, 2025, one single day before the scheduled execution, the Supreme Court gave its answer. Denied. The clock kept moving. David Pittman had 1 day left. Before we move forward, drop a comment right now and tell us what you think. Based on everything you just heard, do you believe the intellectual disability argument deserved a proper hearing in court? Or do you think the planning behind this crime, the cut phone line, the burning car, every deliberate step, tells you everything you need to know about David Pittman? We want to hear your thoughts. And stay with us, because what comes next in this story goes somewhere you might not expect. 34 years. Say that number slowly. Let it sink in. 34 years is longer than most marriages last. It is longer than some people's entire careers. It is long enough for a child born the year of the murders to grow up, finish school, start a family of their own, and still have years left to spare. 34 years is how long David Joseph Pittman sat inside Florida State Prison and waited for something, anything, to change. And during those 34 years, the world outside those walls did not stay still. It changed dramatically. Technology changed. Laws changed. The science of criminal justice changed. And for a brief, remarkable window of time, it looked as though some of those changes might actually reach David Pittman. That is what this story is about. Not the crime, not the trial, but what happened after. The long, grinding, quietly extraordinary legal fight that most people never heard about. A fight that went on for over 3 decades. A fight that came closer to succeeding than most people realize. And a fight that in the end was stopped not by the facts, but by a clock. To understand what happened during those 34 years, you first need to understand something about the death penalty in America that most people are never taught. A death sentence is not the end of the legal process. In many ways, it is just the beginning. After sentencing, a death row inmate has the right to appeal, to challenge their conviction, to bring forward new evidence, to argue that something went wrong in the investigation, in the trial, in the sentencing, or in the application of the law. These appeals can stretch on for years, sometimes decades. Critics say the system drags on too long. Supporters say that when a human life is at stake, it must be done carefully and completely. Both sides have a point, and both sides were watching the David Pittman case. David's first round of appeals came in the years immediately following his conviction. He challenged the evidence. He challenged the reliability of the witnesses. He argued that the trial had been unfair. These are the standard challenges that most convicted defendants raise, and in most cases they fail. David's did too. The courts looked at the case and said, "The jury saw the evidence. The jury made its decision, and that decision stands." David kept filing, kept arguing, kept saying he was innocent year after year. And then in 2002, something happened in a courtroom far away from Florida that would completely change the direction of his fight. The United States Supreme Court issued a decision in a case called Atkins versus Virginia. The details of that particular case are not important for our story. What matters is what the court ruled. They said that executing a person with an intellectual disability was unconstitutional, that it violated the Eighth Amendment, the part of the Constitution that protects Americans from cruel and unusual punishment. The reasoning was this: a person with an intellectual disability may not fully understand the consequences of their actions in the same way others do. They may not be able to assist meaningfully in their own defense, and putting such a person to death, the most final, irreversible punishment that a government can impose, crosses a line that a civilized society should not cross. This ruling was a seismic shift in American death penalty law. Almost immediately, death row inmates across the country and their attorneys began looking at their cases through a new lens. And David Pittman's lawyers looked at their client and saw something, because here is what they found when they dug into David Pittman's history. He had registered an IQ of 70 before he turned 18 years old. The number 70 sits right at the recognized boundary of intellectual disability, not significantly below it, right at the line. Lawyers and doctors would later debate what that number really meant, what its margin of error was, and whether newer testing methods would produce a different result. But what nobody disputed was this: David had spent his childhood in special education classes. He had suffered documented brain damage. Reading was genuinely difficult for him. His lawyers would later say in court filings that he had trouble reading basic words. Things had to be explained to him more than once for him to follow along. And then there was his childhood itself. His mother had beaten him with a belt from the time he was 4 years old, sometimes every day. She had made it clear to her children that they should never report her, because she would be out of any consequences faster than they could imagine, and then they would suffer for it. He had grown up in extreme poverty. The psychiatric treatment he needed as a child had eventually been stopped because his family simply could not afford to continue it. Floridians for Alternatives to the Death Penalty, an advocacy group that took up his cause in his final weeks, said it plainly: violence, neglect, and hardship shaped David Pittman's life long before the state ever called him a defendant. Armed with all of this, David's lawyers began building a new argument. Not about guilt or innocence. Not about what happened on May 15, 1990. A separate, purely constitutional argument. This man should not be executed, because under the law established by the Supreme Court itself, he is categorically ineligible for the death penalty. In 2015, 13 years after the Atkins ruling, David's legal team formally raised the intellectual disability claim in court. And here is where the story takes one of its strangest, most troubling turns. The state of Florida pushed back hard. Not primarily on the facts of the disability claim. They pushed back on the timing. Their argument was straightforward. You missed the deadline. After the Atkins ruling in 2002, the Florida Supreme Court had given all death row inmates with pending appeals until December 1, 2004, a little over 2 years, to formally file an intellectual disability claim. If you did not file by that date, you lost your right to raise the argument later. David Pittman had not filed by that date. His lawyers argued that there were reasons for this, that the system had failed him, that a man with intellectual disabilities and limited reading ability, navigating a complex legal process from a prison cell, might not have fully understood what was happening or what windows were closing. The state said it did not matter. A deadline is a deadline, and then the Florida Supreme Court made a decision that added an entirely new layer of complexity. In 2016, while all of this was still being argued, the Florida Supreme Court ruled in favor of David Pittman on the retroactivity question. They said that the Atkins protections should apply to his case. They said he deserved a proper hearing. For a brief moment it looked like the door might actually open, but it did not stay open because the court is not a fixed thing. Judges retire. New judges are appointed, and as 3 longtime justices regarded as more moderate left the Florida Supreme Court and were replaced by more conservative ones, the court's position began to shift. In 2020, the new Florida Supreme Court reversed the earlier decision. They ruled in a case called Walls v. State that the Atkins protections could not be applied retroactively. In other words, a protection that was created after a person's trial could not go back and help that person, even if they clearly qualified for it under the current law. The door that had cracked open in 2016 was now closed again. Locked. David Pittman's lawyers were furious. They called it a legal trap. A man who might genuinely be intellectually disabled, a man who might be constitutionally protected from execution, was being denied any real opportunity to prove it, not because his claim lacked merit, but because of a procedural timeline that he had missed years ago. They kept fighting. In August of 2025, just weeks before the scheduled execution, Pittman's attorney, Jalissa Fontaine, stood before a judge and said something that deserves to be heard clearly. She said, "If we do not do this, we are running the risk of actually executing an intellectually disabled man here in the state of Florida." The judge who heard that argument acknowledged openly on the record that there was a real risk Florida was about to kill a man who was lawfully ineligible for execution. Think about that. The judge said it out loud in court, with the execution still scheduled to proceed. That judge's concern was not the only judicial voice raised. One of the justices of the Florida Supreme Court itself issued a dissenting opinion when the court denied Pittman's appeal. Justice Jorge Labarga, one of the remaining justices who had been on the court during the 2016 decision, argued that the majority's ruling could deprive certain individuals of any real consideration of their intellectual disability claims. He argued that David Pittman should have been given the chance to present the full picture of his condition to a court. One justice on the highest court in the state of Florida said publicly, "This man deserved better than what he got, and still the clock moved." Now here is something important that the state of Florida argued back, and it deserves to be heard fairly because this is not a simple story with a simple villain. The state's attorneys pointed out that a psychologist's report from 2015, from David's own side of the case, had noted an IQ score of 95. That is well above the threshold for intellectual disability, not at the borderline, significantly above it. They also pointed out something that goes to the heart of the planning argument from Chapter 2. David Pittman had a job. He lived independently. He had built his own tow truck with his own hands. He had cut a telephone line before entering a house. He had driven a car away from a crime scene, abandoned it, returned with his own truck, and burned it. He had done all of that in sequence, in the dark, without being caught in the act. That, the state argued, is not the behavior of someone who cannot understand consequences. And they had a point worth considering. Intellectual disability is not a single, simple condition. A person can struggle significantly in some areas of life while functioning well in others. The legal and medical definition of intellectual disability involves multiple factors, not just IQ scores, but also what professionals call adaptive functioning, the ability to manage daily life, make decisions, understand social rules. The debate between David's lawyers and the state was not just about numbers on a piece of paper. It was about what those numbers actually mean in a real human life. That is exactly the kind of debate that a proper hearing, a real evidentiary hearing, with experts, with records, with full examination, is designed to resolve. David Pittman never got that hearing. The procedural rules said he had missed his window, and those rules, the courts decided, were more important than opening the question one more time. On September 10, 2025, the Florida Supreme Court issued its final ruling. Pittman's intellectual disability claim was denied. The execution would proceed as scheduled. His lawyers immediately turned to the United States Supreme Court, the highest court in the land, the last possible stop. They filed an emergency petition asking for a stay of execution, just a pause, just enough time to argue the constitutional question before the full court. On September 16, 2025, one day before the execution, the Supreme Court of the United States gave its answer. Denied. No hearing, no stay, no pause. Every door had now been closed. Back inside Florida, the machinery of the execution moved forward. Governor Ron DeSantis had signed David Pittman's death warrant on August 15, 2025. DeSantis had been signing death warrants at a pace that had not been seen in Florida in decades. By the time David Pittman's warrant was signed, Florida had already carried out 11 executions in 2025 alone. David would be the 12th, a new record for the state. Critics of the governor pointed to this pace with alarm. They noted that Florida leads the entire nation in death row exonerations. 30 people freed from death row since 1973 after being found wrongfully convicted. One capital defense lawyer and the executive director of a Florida advocacy group put it simply, "We get it wrong more than any other state." Florida's own record, they argued, was reason enough for caution, reason enough to slow down, reason enough to make absolutely certain before proceeding. The governor did not slow down, but outside the walls of Florida State Prison on the evening of September 17th, two very different groups of people gathered, each of them representing a real and legitimate part of this story. On one side, a church group from Daytona Beach that travels 2 hours to attend every Florida execution. They set up chairs and tents and speakers. They sang. They prayed. They believed that something sacred and solemn was happening inside those walls, that even at the end of a life marked by terrible choices, God was present. On the other side, members of Floridians for Alternatives to the Death Penalty stood with signs and a bell. When the hour of the execution arrived, they rang that bell and said the words they always say at these moments, "Not in my name." None of us are going to wake up tomorrow and be safer because David Pittman is dead. Both groups were there because they believed in something. Both groups were expressing something real about the society that produced this moment. Inside, the witnesses gathered. Among them, Marie, David's ex-wife, the woman whose family had been at the center of this entire story for 35 years. She came, she watched, and when it was over, she said something that Polk County Sheriff Grady Judd, who was also present, shared with reporters afterward. She said, "Now I can move on." 3 words, quiet, simple, and carrying 35 years of weight behind them. The sheriff himself was less subdued. He said David Pittman had earned the death penalty 3 times, and that justice had been done. He said Pittman had stayed evil to the end. Outside, the bell rang. Inside, at 6 p.m., the process began. David Pittman was given the opportunity to speak his last words, and he did not stay quiet. He looked at the witnesses and he said, "I know you all came to watch an innocent man be murdered by the state of Florida. I am innocent. I didn't kill anybody. That's it." Then they administered the drugs, a sedative, a paralytic, a drug that stops the heart. At 6:12 p.m. on September 17, 2025, David Joseph Pittman was pronounced dead. Florida's 12th execution of the year. A record. Outside, the bell rang again. Inside, Marie finally had her answer. And somewhere in between all of it, in the space between the bell and the silence, between the sheriff's words and the advocate's words, between the certainty of the family and the dissent of the judge, the question that had followed this case for 34 years was still sitting there, unanswered, unresolved, waiting. We are going to face that question directly in our final chapter. We are going to look at both sides, fully, fairly, without flinching, and we are going to let you decide what you think. But before we get there, we want to know where you stand right now. After everything you have heard across these 3 chapters, drop a comment below. Do you believe the system worked the way it was supposed to? Or do you believe something went wrong somewhere along the way? Every comment matters. Every perspective adds to this conversation. Stay with us for the final chapter, because the ending of this story is not what most people expect. At 6:12 in the evening on September 17th, 2025, David Joseph Pittman was pronounced dead. The needle had gone in. The drugs had done their work. A few deep breaths, then stillness. And just like that, after 34 years, 3 months of appeals, 3 rounds of courts, a last-minute petition to the highest court in the land, and one final declaration of innocence spoken out loud in front of witnesses, it was over, or was it? Because here is the truth about a case like this. The execution does not end the questions. It does not close the debate. In many ways, it makes the questions louder, more urgent, more impossible to ignore. When a person is in prison, there is always the possibility of new evidence. There is always the chance that something changes, that a door opens, that the truth finds a way out. Once an execution is carried out, that possibility is gone. Forever. Whatever the truth is, it now has to live alongside the permanent, irreversible fact of what the state of Florida did on that Wednesday evening. And it is that permanence that makes the final chapter of David Pittman's story so important to sit with. So let us sit with it. Let us look one final time at both sides of this story, not to reach a verdict of our own, not to undo what cannot be undone, but because the people at the center of this case deserve to be seen fully, and because the questions this case raises are bigger than any one man. They are questions about all of us. Start with the Knowles family. Clarence Knowles, 60 years old, a man who had lived in Mulberry, Florida for decades, a husband, a father, a man who, on an ordinary Wednesday evening in May of 1990, had no idea that it was the last night of his life. Barbara Knowles, 50 years old, a wife, a mother, a woman whose children were her world. The kind of person who probably thought that the worst of it was the divorce, that once Marie and David's marriage was over, the trouble would pass and life would go back to normal. Bonnie Knowles, 20 years old, just starting out. The whole arc of her life, the relationships she would have had, the places she would have gone, the person she would have become, all of it ended in that bedroom on May 15th, 1990. 3 people. Real, specific, irreplaceable people. Not symbols. Not statistics, people. And for 35 years, the family members who survived them, the nieces, the nephews, the people who grew up knowing that their mother, their grandmother, their aunt had been taken from them in the worst possible way, carried that. Every day, through every appeal David filed, through every court hearing, through every year the system moved slowly toward this moment. James Geddes, a nephew of the Knowles family, spoke after the execution. He said that it brought a measure of closure to a tragic event that had defined his family for 35 years. He said justice had been served. Those words deserve to be heard without qualification. When a family loses 3 members to violence, and then spends more than 3 decades waiting for the legal process to reach its conclusion, the moment that process finally ends carries a weight that most of us will never fully understand. Their sense of closure is real. Their relief is real. Their right to feel that justice was done is real. That is one side of this story, and it matters completely. Now here is the other side. David Pittman also had a family. He had people who loved him, people who visited him in the final hours before his execution, people who walked out of Florida State Prison that evening in grief, carrying their own kind of loss. The advocacy group Floridians for Alternatives to the Death Penalty issued a statement that same night. They said something worth reading carefully. They said that the victims and the person executed were members of the same family, and that for decades surviving relatives had carried not only the grief of losing loved ones, but also the pain and division of navigating a system that pits them against one another over what justice even means. Think about that for a moment. Marie Pittman, the woman at the center of all of this, had lost her parents and her sister, and then she had spent 35 years watching the legal fight over the man who she was once married to. The man who, depending on which side you believe, either destroyed her family or was falsely accused of destroying it. She came to the execution. She watched. And afterward she said 3 words. Now I can move on. 35 years of her life wrapped up in those 3 words. Whatever she believed, whatever she felt, whatever she had been carrying all that time, she was finally ready to set it down. Both families, the Knowles side and the Pittman side, walked away from that prison that night with broken hearts. Both of those broken hearts are real and valid. That is one of the most uncomfortable truths about a case like this. There is no clean line between the grieving people and the other grieving people. They are all grieving people. Now let us look at the questions that this case leaves behind. The first question, the one that every true crime story eventually arrives at, is the most basic one. Did David Pittman actually do it? The jury in 1991 said yes. The court system over 34 years and countless appeals consistently upheld that verdict. The prosecution's case had motive, circumstantial, physical evidence, and 2 witness testimonies pointing directly at David Pittman. But here is what the defense always came back to. There was no fingerprint evidence at the crime scene tying David to the murders. There was no DNA. The physical connection between David and the crime scene came from a witness who saw a man running away from a burning car and identified him from a photo lineup, not from catching him at the scene. And the most powerful piece of testimony came from a jailhouse informant, a category of witness that the justice system itself has spent decades questioning. 3 members of the jury who heard all of this said, at the penalty phase, that they were not ready to vote for death. 3 people out of 12. That is not a small thing. Now, none of this proves David Pittman was innocent. The evidence against him, taken as a whole, was enough to convince 9 out of 12 jurors beyond reasonable doubt. And reasonable doubt is a high bar. But it is also worth noting that Florida leads the entire United States in death row exonerations. Since 1973, 30 people have been freed from Florida's death row after being found wrongfully convicted. 30, the most of any state in the country. One capital defense lawyer said it plainly, "We get it wrong more than any other state." That does not mean every conviction in Florida is wrong. Most are not, but it does mean that Florida's system, the investigation process, the trial process, the appeal process has produced more documented errors in capital cases than anywhere else in America. And in a system with a documented history of mistakes, the question of whether every safeguard was truly followed in every case is not paranoia. It is just common sense. The second question, the one that outlasted the guilt question, is about the intellectual disability argument. Here is the clearest way to state what happened. The United States Supreme Court ruled in 2002 that executing a person with an intellectual disability is unconstitutional. That ruling is still the law of the land. It has not been overturned. It has not been weakened. It stands. David Pittman had a documented IQ of 70 or 71 as a child. He had been in special education. He had suffered brain damage. His lawyers argued with medical evidence that he fell within the protected category. The state of Florida cited a later IQ test showing a score of 95, and they argued, convincingly enough for 6 of 7 Florida Supreme Court justices, that his functional behavior showed adaptive ability. He had lived independently. He had built a tow truck. He had, according to the prosecution, planned and executed a complex multi-step crime. Both sides of that debate are grounded in facts. This is not a case where one side is making things up. But here is the thing that advocates found most troubling. The argument was never truly resolved on the merits. David Pittman never received a full evidentiary hearing where both sides could present their evidence, where experts could testify, where a judge could weigh everything in full. The door was closed, not because the courts decided he was definitely not intellectually disabled, but because of a procedural deadline, because of a rule about when the argument had to be raised, because of a 2020 court decision that reversed a 2016 decision, which had reversed an earlier position, shifting with the changing makeup of the court. A sitting Florida judge acknowledged openly that there was a real risk the state was executing someone who was legally ineligible for execution. One Florida Supreme Court justice dissented from the majority decision and agreed that David Pittman deserved better. These are not fringe opinions from activists. These are members of the judiciary itself expressing serious doubt, and yet the execution proceeded. The advocacy group FADP put it in sharp, direct language the night of the execution. They asked a hypothetical question that is worth sitting with. If undisputed new evidence came to light today that David was under the age of 18 at the time of the crime, another category that is constitutionally protected from execution, would the state and the courts say that the new evidence came too late? After September 17, 2025, they said, the answer appears to be yes. That is a troubling answer for a society that claims to value justice over procedure. The third question is the biggest one, and it is a question that goes far beyond David Pittman. What is the death penalty actually for? People who support capital punishment give several answers. They say it brings closure to the families of victims. They say it ensures that the most dangerous people can never harm anyone again. They say that some crimes are so severe, so final, so completely destructive of human life, that only the most final and irreversible punishment is proportionate. People who oppose capital punishment give their own answers. They say that the risk of executing an innocent person is too high in any system run by fallible human beings. They say that the death penalty does not measurably reduce violent crime. They say that a government that takes human life in the name of justice is doing something that cannot be undone, and that something which cannot be undone must be held to an impossibly high standard. And in the case of David Pittman, those two sides met head-on. Because even if you believe with complete certainty that David Pittman killed Clarence, Barbara, and Bonnie Knowles, the constitutional question about his intellectual disability was never fully resolved. A legal protection that is supposed to exist was never truly tested in his case. And if you are not completely certain he was guilty, if the absence of physical evidence gives you pause, if the jailhouse informant makes you uneasy, if those 3 dissenting jurors stay in the back of your mind, then what happened on September 17, 2025 carries a weight that is very difficult to put down. Sheriff Grady, Judd stood outside the prison after the execution with David Pittman's 1990 mugshot in one hand and a photo of the Knowles family in the other. He held them up for the cameras. He said he wanted people to see not the 63-year-old man who had just died, but the man who had been arrested in 1990. He was evil then, he said. He was evil to the end. His last public statement was a bold-faced lie. He never changed. Outside the prison walls, Grace Hanna from Floridians for Alternatives to the Death Penalty stood with her group and said something different. None of us are going to wake up tomorrow and be safer because David Pittman is dead. 2 people, 2 statements. Both of them sincere. Both of them reflecting something real about the world we live in and the choices we make as a society. Father Phil Igito, the priest from Our Lady of Lourdes Church who travels 2 hours to attend every Florida execution, said that he believed Jesus, the presence of something sacred, needs to be at every execution, that no matter what a person has done, something profound and irreversible is happening in that room. Whatever your beliefs, religious or otherwise, the idea that something profound and irreversible is happening is hard to argue with. The state of Florida carried out its 12th execution of 2025 on September 17th, a new record. 2 more were already scheduled before the year ended, and somewhere in that statistic, in that number, 12, are 12 human beings who each had a story as long and as complicated as David Pittman's. 12 childhoods, 12 families, 12 sets of victims, 12 courtrooms, 12 sets of questions, 118 total executions in Florida since the death penalty was reinstated in 1976, each one of them permanent. Here is where we leave you, not with an answer, because the truth is that this story does not have a clean one. It has evidence and it has doubt. It has justice that one family waited 35 years to feel, and it has a constitutional question that was never fully answered. It has a man who said he was innocent from the day he was arrested to the moment he died, and it has a jury of 12 people who looked at the evidence and said he was not. What we can say with certainty is this: 3 people, Clarence, Barbara, and Bonnie Knowles, deserved to live out their lives. They deserved to grow old, to see their family grow, to have more ordinary days in Mulberry, Florida. They were robbed of all of that, and the people who loved them carried that loss for 35 years. Whatever else you believe about this case, that is the foundation. Those 3 lives mattered. And whatever you believe about David Pittman, his guilt, his disability, the fairness of his trial, the justice of his execution, the questions his case raises about how we as a society decide who lives and who dies do not go away when the needle is removed and the witnesses leave the room. Those questions stay. They are staying right now, and they will stay long after this documentary ends. Thank you for watching all the way through. This story was not an easy one to tell, and it was not an easy one to hear. If it made you think, if it made you ask questions you did not have before, then it did exactly what it was supposed to do. If you found value in this documentary, please subscribe and share it with someone who you think should hear this story. Leave a comment below and tell us, what question from this case stays with you the most? Because the conversation does not end here. It is just beginning.